NCD Publication, Turning Rights into Reality, continued, page 11. Glossary of terms. ABLE accounts, a type of tax-advantaged savings account established under the Achieving a Better Life Experience, ABLE, Act of 2014, for people with significant disabilities that began before they turned 26 and who meet the Social Security Administration's SSA definition of disability. Eligible individuals who are the owner and designated beneficiary of the ABLE account can use funds from the account to pay for qualified disability expenses, which are defined in the ABLE Act and its regulations. The first $100,000 in ABLE accounts are exempted from the individual's resource limit for Supplemental Security Income, SSI. ABLE accounts are disregarded for the purpose of determining if a person meets the asset limit for Medicaid. For more information, visit http://ablenrc.org. Education. The process of a judicial determination, an adult under guardianship has generally been educated to lack capacity. Adult, an individual who is at least 18 years of age. Advance directive, a witness document or documents that a person can use to provide instructions regarding their desires and preferences about medical treatment in the event the person becomes incapacitated. Such medical treatment may include, for example, life-prolonging treatment or psychiatric treatment during a crisis. Often, an advance directive will include a power of attorney and a healthcare surrogate designation. Agent, a person with the legal authority to act on behalf of another. Alleged incapacitated person, AIP, a person who is the subject of a petition to determine capacity or guardianship, but who has not yet been adjudicated incapacitated. Annual accounting, a report filed by a guardian of the property that some states require to be submitted to the court each year, itemizing expenditures and receipts made on behalf of the person. Some states allow the court to waive this requirement, particularly if the only income the person has is Social Security and the guardian is also the representative payee of such funds. Annual Guardianship Plan. A report filed by the guardian of the person that some states require to be submitted to the court each year, specifying the medical, mental, and physical care of the person in guardianship for the upcoming year. Attorney ad litem, an attorney who is appointed by the court to act as the legal advocate in the best interest of a child or incapacitated adult. Unlike attorneys in a normal attorney-client relationship, attorneys ad litem do not necessarily advocate for the desired outcome of the individual they represent, but they may advocate for an outcome the attorney ad litem deems in the person's best interest. Best interest, a type of decision-making standard that may be used when deciding on behalf of another person, particularly in court cases involving child custody or welfare, compared to substituted judgment. The best interest standard tends to prioritize the person's safety and well-being rather than their expressed wishes. While traditionally linked with decisions made by guardians, it is now considered the less preferred decision-making standard. For example, the National Guardianship Association standards indicate that only when the person's goals and preferences cannot be ascertained may the guardian make a decision in the person's best interest. Page 12. Capacity. An individual's ability to perform a specific task, such as to sign a contract. The term also refers to the legal ability to perform an act and to subsequently be bound by the act. May also be referred to as competency. Case management services. Coordinating services through community and government agencies, the extent of which depends on the specific state. Clerk of the court. A court officer responsible for filing papers, administering cases, and keeping records of court proceedings in some courts. The clerk of the court may play a role in reviewing accountings and reports filed by guardians. Conflict of interest. Situations in which an individual may receive financial or material gain or advantage from a decision made on behalf of another person with whom they have a relationship. Court visitor or monitor. A person appointed by a court to advise the court regarding whether an individual needs a guardian and, if so, who it should be, or to report to the court whether an existing guardianship continues to be appropriate or necessary, what the condition of the individual in guardianship is, or whether the decisions being made on behalf of that individual are appropriate. Durable power of attorney. A durable power of attorney is effective even after the principal becomes incapacitated and unable to make decisions. The agent appointed by the principal in a durable power of attorney can continue to act within the scope of authority granted under this legal document. Family guardian, a non-professional guardian who serves as guardian for an individual. Although family guardians usually are related to the individual, they may be friends or even volunteers. Although they may be able to be reimbursed out of the individual's estate, family guardians do not serve as guardians in order to make a living. The definition of family guardian may vary from state to state. Guardian, a person, institution, or agency appointed by a court to manage the affairs of another individual. The guardian may have the authority to manage personal and/or financial matters. Each state has specific laws that govern guardianship proceedings and the guardian's activities. States have separate laws and procedures regarding guardianship for minors and adults. States may use different terms to refer to guardians, such as conservators. Guardian ad litem, a person appointed to advise the court regarding the needs and best interests of a child or individual who either lacks capacity or, in some states, has been alleged to lack capacity. Guardianship of the person. A guardianship where the guardian is granted the authority by the court to make personal decisions for an individual. This means that the right to make personal decisions has been removed from the individual and transferred to a guardian. These rights may include, for example, the right to decide where to live, with whom to associate, and what medical treatment to receive or not receive. Guardianship of the property, a guardianship where the guardian is granted the authority by the court to manage and make decisions about another person's financial matters, benefits, real estate, and other property. This means that the right to make property decisions has been removed from the individual and transferred to the guardian. This is sometimes referred to as a conservatorship or guardianship of the estate. Healthcare surrogate, an agent who has been given the authority to make healthcare decisions for a person, either by the person through a durable power of attorney for healthcare or by the operation of law. Page 13 of the glossary. Incapacitated. The current term used by most courts that employ a combination of medical and functional criteria to reach a determination that a person cannot exercise specific rights. Generally speaking, a person who is incapacitated has been determined by a court to be unable to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care. However, the concept of capacity is a social and legal construct that is not necessarily provable or disprovable through scientific methods, and the use of the terms capacity and incapacity is becoming disfavored by guardianship reformers. For example, the 2017 Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act makes no reference to either term. Indigent, an individual with little to no resources who may be entitled to an attorney paid for by the state, the appointment of a public guardian, and/or the waiver of court costs and fees. Informed consent, consent, usually to a medical procedure or legal representation given by a person after information disclosing the risks, benefits, and cost of undertaking a given action are divulged, so the person may make a free and uncoerced decision. Joint ownership, a situation in which two or more people co-own property. It allows a co-owner of land or bank accounts to manage an incapacitated co-owner's property as their own. Limited guardianship, a guardianship where the guardian only has the authority specifically given by court order. The person in a limited guardianship retains all other decision-making rights not specifically outlined by the court order. Magistrate judge, a state official who makes decisions in legal cases just like a judge but does not have as much power as a judge. A magistrate judge generally handles minor cases and in some jurisdictions may handle guardianships cases, especially those that are uncontested. Money management services. Services that help people with their financial affairs, such as check depositing and writing, bill paying, budgeting and checkbook balancing, and tax preparation. Money management services are voluntary, so the person must be able to ask for or accept them. Physician orders of life-sustaining treatment. POST. The POST process requires a discussion between the treating healthcare practitioner and the person about key end-of-life care treatment options, so that the person's wishes can be identified and incorporated into doctor's orders kept in the medical record or with the person. Those orders are reviewed periodically and must travel with the patient whenever he or she moves from one setting to another, thereby promoting continuity of care. Plenary guardianship. A full guardianship where the court gives the guardian the power to exercise all delegable legal rights and duties on behalf of the person in guardianship. The guardianship is of both the person and the property, and the individual in a plenary guardianship has been adjudicated completely incapacitated. This is the most restrictive form of guardianship. Power of attorney, a legal document executed under state law whereby one person, called the principal, voluntarily designates someone else, called the attorney in fact or agent, to legally act on their behalf for certain decisions and in certain circumstances. A durable power of attorney continues even after the individual has lost capacity. A power of attorney for healthcare usually goes into effect when the person becomes incapacitated. Professional guardian. A professional guardian is generally a private individual or organization who serves as guardian for numerous individuals and is not a member of those individuals' families. Professional guardians charge fees for carrying out their duties. They are generally paid out of the resources of the person subject to guardianship when that person has such resources. Page 14. Public guardian. A guardian who generally is either employed or funded by the state or local government to provide guardianship services to individuals who have been determined incapacitated. Often public guardians serve people who are indigent and/or are the responsibility of a governmental agency or entity. Representative payee, an individual agency or organization appointed by the Social Security Administration, SSA, to receive, manage, and spend Social Security benefits on behalf of and for the benefit of an individual who is entitled to the benefits, but who has been determined by SSA to be unable to manage the resource. Respondent, a person who is responding to a lawsuit or legal action in guardianship. The alleged incapacitated person is the respondent. Special needs trust, a type of trust that is established for the benefit of a person with disabilities. The assets in this type of trust are intended to supplement and protect public benefits, specifically Medicaid. The advantage of this type of trust is that its assets do not negatively impact the beneficiary's eligibility for Medicaid or other government programs if the trust is administered properly. Standard of proof refers to the duty or burden carried by the party responsible for proving the case. There are generally 3 standards of proof that can apply in legal cases. Beyond a reasonable doubt, highest standard, applies in criminal cases and in guardianship cases in New Hampshire. Clear and convincing, second highest standard, which applies in most states' guardianship cases, and preponderance of the evidence, lowest standard, which applies in some states' guardianship cases and also may be the burden of proof in restoration cases. Substituted judgment, a standard of decision-making that should generally be used when making decisions on behalf of an adult with a disability. According to the National Guardianship Association, it refers to deciding on behalf of an individual in a manner that is aligned with the decision they would have made for themselves if they had the capacity to do so. This includes understanding and considering the values and preferences of the individual for whom decisions are being made, either as currently expressed or as expressed prior to the determination that the individual was incapacitated. Support decision-making. There is no singular definition or model, but this generally means an individual choosing one or more people to assist that person in understanding the nature and consequences of potential personal and financial decisions, supporting the individual in making their own decisions, and then communicating decisions as needed. It generally occurs when people with disabilities use friends, family members, and professionals to help them understand the everyday situations they face and choices they must make, allowing them to make their own decisions without the need for a substitute decision maker, such as a guardian. This process works in the same way that most adults make daily decisions, by seeking advice, input, and information from trusted, knowledgeable others. Trust, a fiduciary arrangement where the trustee manages money or property for the benefit of a beneficiary or beneficiaries. A trust is a separate legal entity that owns assets that are managed by the trustee for the benefit of the beneficiary or beneficiaries in accordance with the rules established by the trust. There are many kinds of trust, each of which provides different benefits. Executive Summary, page 15. In March 2018, the National Council on Disability, NCD, released a seminal report, Beyond Guardianship, toward alternatives that promote greater self-determination for people with disabilities, which provided a comprehensive review of adult guardianship through the lens of civil rights reforms impacting people with disabilities. The report cited serious problems about how guardianship systems function in the United States, including lack of reliable state and national data on guardianship, misperception about the ability of people with disabilities to make autonomous decisions, denial of due process within guardianship proceedings and meaningful consideration of less restrictive alternatives, insufficiencies in capacity determinations, lack of court oversight of guardians, and inaccessibility and underutilization of rights restoration processes after a guardian is appointed. In addition to its detailed findings, the 2018 NCD report offers recommendations for reforms to improve the lives of people with disabilities who may need decision-making assistance. It also suggests reforms to prevent overly broad or undue guardianships and to improve court oversight of the existing guardianships to eliminate abuse, neglect, and exploitation. The present report builds upon the work of the 2018 NCD report by specifically examining the role of guardianship and other alternatives in the lives of people with intellectual and developmental disabilities, IDDD, a population that is known to be at increased risk of having guardians. The report also examines if the increased risk for people with IDDD may be linked to the different ways states apply guardianship laws, as well as biases and/or assumptions about the ability of people with IDDD to fully experience the dignity of risk. Some view guardianship as necessary to protect people with IDDD. Others raise concerns about its stigma, and how it impacts the civil rights and personhood of people with IDDD. Like its predecessor, this report seeks to acknowledge and balance both of those views, while holding to the belief that people with disabilities both desire and deserve choices when seeking assistance with daily living that maintains their self-determination and maximum dignity and independence. Summary of methodology. The 2018 NCD report provided a broad overview of the current state of guardianship law and practice, as well as policy reforms and analysis of how effective or ineffective those efforts have been. Page 16. The present report uses that overview as a springboard to explore the experiences of people with IDDD, their families, and others through a multi-model blend of updated literature review, data analysis, key informant interviews, targeted outreach, and personal story gathering from stakeholders. This report is organized into 6 chapters. Chapter 1, briefly explains what guardianship is and includes cross-references to the lengthier explanation in the 2018 NCD report. It also introduces the reader to what is meant by IDDD and how people with IDDD are at an increased risk for having guardians. It also explains how guardianship, while directly governed by state law, can negatively implicate important federal civil rights for people made subject to it. Chapter 2 describes what has become known as the school to guardianship pipeline, as well as its impact on youth with IDDD. It examines U.S. policy implications of this pipeline under important federal laws, including the Individuals with Disabilities Education Act, IDEA, the Developmental Disabilities Assistance and Bill of Rights Act, the Americans with Disabilities Act, ADA, the Rehabilitation Act, and the Workforce Innovation and Opportunity Act, WIOA. Chapter 3 explores how some states' guardianship laws have different standards and processes for obtaining guardianship over people with IDDD than other populations who need decision-making assistance. It also discusses the impact of the disparate treatment of people with IDDD, as well as U.S. policy implications, which include concerns about the lack of procedural and substantive due process and the potential for discrimination based solely on disability diagnosis. Chapter 4 acknowledges the 2018 NCD report findings about the lack of reliable and consistent national and state data on guardianship. It includes an analysis based on available national core indicator data, which addresses key questions about guardianship and people with IDDD, including whether or not people with IDDD who have guardians are more or less likely to live in restrictive environments than those who do not, whether guardianships for people with IDDD are increasing or decreasing, and what the prevalence of guardianship broken down by race and general age group. Chapter 5 gives an in-depth analysis of guardianship's impact on people with IDDD within Washington, D.C., including never-before-published trends in D.C. guardianship, data and lessons that other states can learn from D.C.'s experience. Chapter 6 summarizes the input this project received from stakeholders who responded to our call for their experiences with guardianship and alternatives. This includes people with IDDD, their family members, and other stakeholders, such as education advocates, guardians, and administrators of guardianship programs and staff who provide transition services to youth with IDDD. Page 17. To gather information from stakeholders, NCD developed templates to gather input through emails, an online tool, and personal interviews. NCD ultimately received 70 substantive responses from 19 states and the District of Columbia. Finally, Chapter 7 offers NCD's findings and recommendations considering the information presented in this report. Page 18 is blank. Executive Summary in Plain English, page 19. The National Council on Disability, NCD, is a group that works to help the government learn about how they can help people with disabilities. One way we do this is by writing reports about different topics that are important to people with disabilities. Like this one, we wrote this summary in plain English to make it accessible to everyone. NCD wrote a report about guardianship in March 2018. Guardianship is when someone, like a family member, friend, or paid person, is chosen by the court to make legal decisions for a person. In that report, we looked at rights of adults with disabilities, guardianship, and other ways people make choices in their lives. We found many problems with guardianship in the United States. Sometimes governments and courts think people with disabilities can't make decisions for themselves. Sometimes people with disabilities can't ask to change or get rid of their guardian, even if they feel the guardian isn't helping them. Sometimes they can't report problems with their guardian or figure out other ways to make decisions without a guardian. Judges don't always pay attention to what the guardians are doing, even if a guardian has caused problems before. But people who have guardians still have some rights. Once a person gets a guardian, they don't always need one forever. but some people don't know that NCD talked about how to help more people with disabilities make their own decisions with the support they need and want. We also explained how guardians and courts could do a better job without hurting people with disabilities. We know that there are many people with intellectual and developmental disabilities who have guardians. We wanted to focus on that, so NCD wrote this second report. We also wanted to know if more people with intellectual and developmental disabilities have guardians now than they did before. States have different guardianship laws, and that can be confusing for people with disabilities, family members, and judges. Sometimes people think that if you have an intellectual and developmental disability, you can't make decisions for yourself. They think you could get hurt, even though everyone makes bad decisions or gets hurt sometimes. There's a big debate about guardians. Some people think guardians are a really good thing. They can help protect people with intellectual disabilities and help them make decisions. Some people are worried about guardians taking away the rights of people with disabilities or making bad decisions. Some people are embarrassed about having a guardian. NCD believes guardians are not always bad or always good. You should not be embarrassed if you need or want a guardian, but people with intellectual and developmental disabilities should always get to make decisions about their lives. Page 20. You should be able to tell other people about any problems you're having. You should always have rights and choices. Sometimes a guardian can help with these things. Other times, a person with an intellectual and developmental disability might not want or need a guardian. We did a lot of work before we wrote this report. We talked to people with intellectual and developmental disabilities and their families and listened to their stories. We talked to experts who know a lot about guardianship. We read what people wrote about guardianship. After all that, we wrote this report. We came up with a lot of ideas about how guardianship in the United States should be made better for people with intellectual disabilities. We also talked about how other options besides guardianship should be used when they can. We are asking the federal government to think and make changes based on our ideas. Page 21, List of Acronyms. ACL, Administration for Community Living. ADA, Americans with Disabilities Act. ADAA, ADA Amendments Act of 2008. AIP, Alleged Incapacitated Person. AP, Associated Press. APS, Adult Protective Services. CMS, Centers for Medicare and Medicaid Services. CRPD, United Nations Convention on the Rights of Persons with Disabilities. DOJ, U.S. Department of Justice. EAHCA, Education for All Handicapped Children Act. FHAA, Fair Housing Amendments Act of 1988. HCBS, Medicaid Home and Community-Based Services. HHS, Department of Health and Human Services. IDDD, Intellectual and Developmental Disabilities. IDEA, Individuals with Disabilities Education Act. IEP, Individual Education Program. NCD, National Council on Disability. NIDILRR, National Institute on Disability, Independent Living, and Rehabilitation Research. NQE, National Home and Community-Based Services Quality Enterprise. OSEP, the Office of Special Education Programs at the U.S. Department of Education. OSERS, the Office of Special Education and Rehabilitative Services at the U.S. Department of Education. PNA, Protection and Advocacy. SAMHSA, Substance Abuse and Mental Health Services Administration. SDM, Supported Decision Making. SSA, Social Security Administration. SSI, Supplemental Security Income. UCEDDS, University Centers for Excellence in Developmental Disabilities. UGCOPAA, Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. UGPPA, Uniform Guardianship and Protective Proceedings Act. VA, U.S. Department of Veterans Affairs. WINGS, Working disciplinary networks of guardianship stakeholders. WIOA, Workforce Innovation and Opportunity Act. Page 22. People with IDDD have been the target of stigma, segregation, and low expectations throughout history. While some of these beliefs and practices persist today, significant progress has been made in the past 50 years.